Good morning, everyone, and welcome to CHM's first webinar for the year. Thank you very much for joining us. We hope it will be a very insightful session. You'll see somewhere on your screen all of our panelists, and you'll get to meet them as we go through the webinar over the course of the next 90 minutes. If I could just ask them to turn their camera off for now. This is, as I said, our first webinar of the year, and I think it's useful always for us to recap what happened in the year that went by. Many of you will share our feeling that the years just go by in a flash, and often we haven't fully had a chance to appreciate what happened in the year that went by, particularly in the context of employment law. I mean, we have the librarian of the library of the Labour Court sending out judgments on a weekly basis, and there are dozens of them. And I think even employment lawyers struggle to keep up sometimes. Last year was a tremendous success on our In Case You Missed It. It was the first time we ran it, and we had wonderful feedback. This year, we've also had a pretty good response, and we hope to carry this on next year again. This year, we'll be dealing with very similar topics as we did last year: collective bargaining and strikes, misconduct, Section 197 transfers, retrenchments, and restraints of trade. As I said, this is for about 90 minutes. We've tried to structure it in such a way that we can take some questions at the end, and I hope we get there. If you have questions, by the way, just use the Q&A function, please, and then we'll go through them towards the end. Just to remind you that this video will be posted on our YouTube page, and at the end of it, we'll also be sending a short summary of the cases that we've discussed, just so that everyone has the context. I'm sure somebody's going to comment for the case references. They will be contained in that document, I promise you. So they're on their way to you. So I have the pleasure of starting off the webinar with the first topic. Last year, I spoke about collective bargaining and strikes, and I'm going to do it again this year. I think that the best place to start, if we were to look at what happened last year, is to think about the Labour Relations Amendment Bill, which has been kind of in quiet circulation since November 2024. Not much happened last year. There was some discussion about it. There were some articles published. There are, as usual, a whole bunch of issues that will provoke debate about the issues that NEDLAC seeks to amend. I suppose in the context of collective bargaining, there are two major developments. The one is a move to exclude new business or new businesses from bargaining council arrangements. So what is a new business? In terms of the bill, a new business is one that has been operating for less than 2 years and employs less than 50 employees. So I think these are positive moves. We saw similar things in the Employment Equity Act in relation to compliance with affirmative action policies. So I think that this is a positive move. You can see there's an increased focus to kind of unburden smaller employers and newer businesses from all the regulation that's currently in our labor market. And I think it's something that we should support. Some of the changes also impact upon large-scale retrenchment exercises, which now, if the amendment goes through, will designate the facilitator in a large-scale retrenchment as a conciliating commissioner, and then will allow them to issue picketing rules in terms of Section 69. So it cuts out that process where once you've issued the notice of termination, there's no need any longer to go to the CCMA to obtain picketing rules. It could be dealt with in that sitting. And then an important one that I quite like is proposed new obligations on unions and employers' organizations to comply with financial reporting standards that are prescribed under the Companies Act. I think many of us deal not only with unions, but some employers' organizations who really are fly-by-night. The majority of them are not, and they're properly structured organizations, but there are many that fail to comply with their financial reporting obligations. And the registrar is well aware of this. So I imagine that amendment came through from the registrar's office, or at least the proposal on it. The other big thing that happened in collective bargaining and strikes was the Code of Good Practice on Dismissal, which arrived in September 2025. And it dealt with a whole bunch of new issues, and it revamps some of the existing provisions, including those on strikes and discipline arising from strikes. Now, the important provisions here that have been introduced by the Code of Good Practice, and Hedda and Merlisha did a webinar last year on the Code of Good Practice in some detail. But just at a high level, those that affect collective bargaining and strikes is the introduction of a list of factors to consider when determining how serious the misconduct of participating in an unprotected strike is. Now, the code says that you must take into account the conduct of the parties, the legitimacy of the demands, the duration and timing of the strike, and the harm caused by the strike. All of those things must be considered before any decision to dismiss is taken. And when one is taken, those are the criteria against which it will be assessed. There's also a detailed section in the new code dealing with the process to be followed before dismissing employees who engage in an unprotected strike. Previously, there was one paragraph in the Code of Good Practice that dealt with it. It's now been separated into about 10 or 12 kind of individualized issues that should be dealt with in the process. First, alert the trade union rep, and it works its way all the way through. One of the important provisions there is that it says that employees who reject an ultimatum may be dismissed by an employer after considering the conduct and any representations that the employees may make. So this is not new in terms of our law, but it certainly is new in terms of the code. It's basically a codification of some of our case law over the years, and that's great. Unfortunately, though, neither the Labor Relations Amendment Act or Bill, or this Code of Good Practice that came in deal with violence in any material respect. And as we know, this is something that is long overdue. The word violence is still not even mentioned in those documents. In relation to judgments, collective bargaining and strikes, I think, are kind of settled at this point in time, but there were two interesting judgments from the Labour Appeal Court, and I'm going to deal with them briefly. So the first one was Shaven Gibson versus Amitu and others, and this was handed down on the 28th of May, 2025. What this case essentially dealt with was a breach of picketing rules. There were a number of different issues, but what I'd really like to focus on is this breach of the picketing rules. What seems to be transpiring in the case law is an increased focus on the picketing rules as a way to deal with an unruly strike that is protected. Now, what happened here is the employer had obtained an interdict, and part of that interdict was a court order that set out a demarcated area for picketing, subject to what would happen at the CCMA when the CCMA determined picketing rules. When the CCMA determined the picketing rules for this protected strike, it basically adopted the same area for picketing as the Labour Court had done in its order. And it had designated a specific piece or area outside the employer's business for the strikers to picket. Notwithstanding that, the employees continued to picket day after day outside of the area. The employer would actually put up red hazard tape to demarcate this as the area. And each day the tape would be destroyed and employees would picket outside of that. What the evidence showed in this case was that the employees were well aware of the court order and the CCMA picketing rules, and that their conduct disrupted the employer's operations unlawfully. So you have a judgment here or a court order from the Labour Court as well as CCMA rules saying how you can picket, and they were just blatantly ignored. Now, the majority judgment, which I think is a very good one, by Judges Governji and Van Niekerk, found that this was serious misconduct to breach the picketing rules, and it was really akin to gross insubordination. And I think that's absolutely right. They knew the rule, which had been designated by the CCMA and the Labour Court. The rule was reasonable, and they just chose to flout it. It was really a challenge to the authority, not only of the employer, but to the authority of the Labour Court and the CCMA. There are some very encouraging words in the judgment. One of the sentences that I like is that obedience to court orders is a foundational feature of a state based on the rule of law. And I think that once people start ignoring court orders, then what is the point, really? We would descend into a society of chaos. And I think these are very strong and timely messages from the Labour Appeal Court. What the court also said was that even though employees have a right to assemble, demonstrate, and picket peacefully and unarmed, by the way, this cannot undermine the importance of employees' compliance with reasonable work rules. Those work rules were that you could picket in a particular place, and they just ignored them. The employer's rule here was a sensible operational response to risk management. And we've heard those words before, very famous from the Labour Appeal Court many, many years ago in De Beers. There was a minority judgment by Judge Savage, which I'm afraid to say I don't agree with, which seems to suggest that the employees should not have been dismissed, despite the fact that they had breached the court order, the CCMA picketing rules, and instructions from management for them to comply with those orders. It's difficult to understand the basis upon which the minority judgment differed from the majority, but it is what it is. The other judgment that is of interest, I think, is Bentella versus NUMSA. That was handed down a few weeks ago on the 30th of January, but the matter was heard towards the end of last year, I believe in September. What you had here was 30 employees who were dismissed for engaging in a work stoppage of about 40 minutes because they had demanded to meet with the manager to talk about their COVID TERS subsidies. We've all mostly forgotten about COVID, but there's still disputes about it. What happened here was that these employees who had engaged in this work stoppage for about 40 minutes, there was a chairperson that had been used. And it was the same chairperson. There were two disciplinary inquiries held, one for AMCU members and one for NUMSA members. So even though this dispute deals with an unprotected strike, the takeaway from this judgment is slightly different because it deals with procedural fairness in the context of disciplining strikers. Now, the Labour Court here found that the disciplinary inquiries were procedurally unfair because the chairperson had been tainted by sitting in the first inquiry. So he sat in the first inquiry for the one union, heard the evidence, the same witnesses, the same charges, the same facts, and what the Labour Court said is that he couldn't possibly have come to a different conclusion on the second inquiry because he'd already heard all the stuff. So on that basis, it found the dismissals to be procedurally unfair. Now, the Labour Appeal Court did not agree with this. And again, I think this is an important development here. What the court said was that our law has evolved from strict formalism to pragmatism with a ring of informality, and it allows employees to respond to the evidence gathered. It endorsed Avril Elizabeth and the new Code of Good Practice, which is extremely important. I think it's going to be a theme throughout this webinar. And what it said is that both Avril Elizabeth and the new Code of Good Practice is consistent with pragmatism in the workplace. And the procedure now is aimed at genuine dialogue and an opportunity for reflection. Absolute neutrality, I think this is also very important. Absolute neutrality from a chairperson of an inquiry is an ideal that is difficult to achieve in the sphere of industrial relations. So I think that even the Labour Appeal Court has accepted that there is no truly impartial person that could chair a disciplinary inquiry. What this really means is that it's an affirmation that employers don't always need to get someone from outside their organization to chair inquiries. That is not what the Code of Good Practice entails. So those were the two cases that I thought were interesting. The takeaways looking at the topic of collective bargaining and strikes, I think, are this. And you can go and tell all your colleagues when you're done with the webinar that this is what happened in collective bargaining. I think we need to look out for the changes to the Labour Relations Act this year. We need to stay in the loop on the amendments. Those are on their way. Hopefully it will happen this year. We are tracking them. Obviously, we're very interested in those developments. But employers' organizations must become involved. If there's an opportunity to comment and participate in that process, they should do it. The focus appears to be on easing regulation for smaller or newer employers, and this should be supported, I think. A court interdict, as we can see from the cases, a court interdict remains a good remedy. And it's a strong statement on the rule of law and compliance with court orders and picketing rules by the Labour Appeal Court. They've come out strongly in support of the rule of law, which is great. And then 2025 introduced the new Code of Good Practice, and it should be interpreted in a way that introduces more flexibility and informality. And this was also confirmed by the Labour Appeal Court. So I think those two cases really helpful for employers, something that we must just keep in our minds if we have to deal with these issues in the future. But as always, the guiding principle is fairness. Right. So I think that deals with collective bargaining and strikes. I'm going to hand over to my colleague, Nicola Watson. She's a senior associate in our employment law team. She's going to be dealing with Section 197 transfers. Take it away, Nikki.
Good morning, everyone. Today I'll be speaking on a particularly nuanced aspect of our labour law, transfers of business in terms of Section 197. More specifically, I will focus on two recent Labour Appeal Court judgments from 2025 that dealt with transfers of business as a going concern following the termination of a service contract. The primary focus will be on the matter between King Coetzer District Municipality versus the Water and Sanitation Services South Africa, and a brief discussion on a judgment issued in November last year between Electro Hydro World and Murray and Roberts. In 2003, the King Coetzer Municipality awarded a tender to WSSA, which is a company that supplies and maintains water and wastewater treatment facilities. Two further tenders were also awarded, which ran until June 2015. After the third tender was finalized, the parties elected to enter into a service level agreement, which was annually extended up until June 2020. Before the final extension of the SLA, WSSA raised the issue of the application of Section 197 in terms of a clause contained in the SLA titled Key Labour Principles. The 666 employees, which is a rather ominous number, employed by WSSA would be given the option of being transferred to either the municipality or the new service provider. When the SLA expired, the municipality denied that Section 197 applied and contended that WSSA was attempting to avoid its financial obligations by transferring the employees instead of embarking on a retrenchment exercise. On appeal, the main issue that had to be determined by the Labour Appeal Court was whether the return of assets owned by the municipality to it by WSSA constituted a transfer of a business as a going concern. The assets in question included the core infrastructure that was owned by the municipality, but used by WSSA to deliver bulk water services, and consisted of its boreholes, pipelines, and reservoirs. The municipality argued that the return of municipal assets could, in theory, constitute a transfer, but because not all of the assets were transferred, it had attempted to align itself with the principles established in the rural maintenance judgment. A secondary issue that the Labour Appeal Court had to determine was whether the retained assets of WSSA, which were its own vehicles, the laboratory equipment, and its office space, constituted core assets required for the provision of bulk water services. The court found that those assets didn't change the fact that the same business continued just in different hands, and therefore they did not constitute core assets. The core assets required for the business, which were owned by the municipality, were returned upon the termination of the SLA. And the court placed a heavy emphasis on the fact that it is an asset-reliant service rather than a labor-intensive one. The court found that the business of supplying the bulk water services was indeed a going concern because, in substance, there was virtually no difference in how it was conducted before and after the expiry of the SLA. The municipality's residents continued to receive the same water supply services. Now, the LAC made a distinction in that the rural maintenance judgment, which is what the municipality attempted to align itself with, in that case, there was no return of core assets that was required for the business. And instead, the court found that it fell squarely within the ambit of the principles established in the City Power versus Grandpol judgment, as the core assets in that instance which were owned by City Power were returned and provided to the new service provider, who then managed the same business. Ultimately, the result was that the Labour Appeal Court found in this instance that all three requirements for Section 197 were met, and that there had been a transfer of a business as a going concern from WSSA to the municipality. Now, turning briefly to the judgment of Electra Hydro World, Murray and Roberts had operated grout plants for Sibanye Gold since 2005. In 2021, they were appointed to one of its mine shafts and employed 63 workers. In 2023, Sibanye issued a tender for 2 new larger plants to increase production, and Electra Hydro were successfully appointed in that. They, however, argued that they were not the successor to Murray and Roberts for the following reasons. They were building new plants that were geographically, technologically, and operationally different from the old plants. They used a different shift system, and they pointed out that Murray and Roberts had kept some of their own assets, such as computer software and payroll system. In that case, the tender document contained a clause which referenced Section 197. Electra Hydro argued that it was a non-binding provision, whereas Murray and Roberts contended that it signaled at least an expectation that Section 197 would apply in the event of a change of service provider. The Labour Appeal Court again looked at substance over form and found that the core infrastructure and economic activity, which was to produce and pump grout, using Sibanye's infrastructure, remained constant. The new technology and different shift systems that were merely operational distinctions that didn't change the essential nature of the service, and the 63 employees were deemed transferred. Notably, the LAC in that case also relied quite heavily on the reasoning in the Coetzer judgments. Now, some of the comparisons to be drawn between these two judgments, they both deal with asset-reliant services rather than labor-intensive ones. The core infrastructure or essential components were owned or provided by the client. In the case of King Coetzer, we have the boreholes, pipelines, and reservoirs. And in Electra Hydro, we have the grout plants and utilities. Those assets were transferred. Both cases contemplated Section 197. As I've mentioned previously, the service level agreement had a key labor principle clause, and in Electra Hydro, the tender document also made provision for 197. And while these contractual references to Section 197 are relative, they aren't decisive, and the substance of the transaction is what matters. Interestingly enough, both cases were initially referred to the Labour Court by way of a declaratory application, and have both ultimately ended up in the Labour Court, and both rendered very similar outcomes. The two cases reiterate several principles established in earlier jurisprudence, such as the Constitutional Court judgments handed down in Nehawu and Tasima. As established in Nehawu, Section 197 must balance two goals: facilitating commercial transactions and protecting workers against unfair job losses. And the distinction made in Tasima was that a business which is asset reliant, where there is a failure to transfer employees or non-core assets, is of no moment. Now, on a final note, the King Coetzer matter was recently argued before the Constitutional Court in November 2025, and judgment is still pending on that matter. But for present purposes, these two Labour Appeal Court judgments affirm that the principle of a holistic factual assessment determines if a business retains its identity after the transfer. The non-transfer of employees or certain assets is not in itself decisive. The application of Section 197 depends on the substance of the transaction and not the contractual labels attached. And where there is uncertainty in whether the application of Section 9 is triggered, a declaratory application can be brought to the Labour Courts. That will be my contributions. Thank you so much for your time, and I'll hand back to you, Neil.
Thanks, Nikki. I have some things I just want to chat to you about. So these are the developments in the LAC. You say we've now got another case on 197 going to 197 to the Constitutional Court. Are they going to clarify anything else for us? We've had about 6 or 7 judgments in the Constitutional Court. Is there any new wisdom we're going to see?
I don't believe that these will fundamentally change the law as we know it on 197. Particularly when we look at Tasima, which has already dealt with the issue of business that's asset reliant and what constitutes the core assets necessary for a business or a service to continue after the termination of a contract or the sale of a business. I don't seem to think that it's going to add anything new to our law, but that's obviously just my opinion on the matter.
No, but what it does show, and I think this is important, is that Section 197 is like high stakes kind of stuff, So the old employer may want to offload some employees onto the new employer. The new employer has its own workforce, so it doesn't want to take them. So this Section 197 is obviously very contentious, and it's so contentious that we need to litigate all the way to the Constitutional Court. But is this section actually that complicated, or do you think it's just employers trying to avoid the consequences of the section?
I think the principle has always stood is that Section 197 applies by operation of law, and whether there's a contractual agreement that makes provision for it, the facts are that if it applies, it applies. It's something that can't be escaped. And I think that perhaps there's just been a conflation of issues and it's made it unnecessarily complicated.
Do you not think, this is the last question, I promise. I'm not trying to put you on the hot seat here, but these are just ideas that pop into my head. Do you not think that employers, instead of trying to fight through these 197 arrangements, should perhaps consider changing the consequences of them in terms of 1976?
Yeah, obviously there is that option afforded to the old employer and the new employer to reach an agreement and iron out these issues before it has to end up being litigated for years down the line.
Very expensive litigation.
Certainly.
All right. Thanks, Nikki. That was very useful. Thanks very much.
Right. Thank you.
All right. So next up is Hedda Schensema. She's an executive in our employment team as well. Hedda, you're going to be chatting to us about retrenchments in 2020.
Yes, good morning. Thanks, Neil. Good morning, everyone. In respect of the case law on retrenchments, we'll be dealing briefly with 3 judgments that we found of particular importance. The reason why we've selected these cases is just to show that there's an intensified judicial focus on meaningful consultation, proper consideration of alternatives, and responsiveness to changing circumstances. While we know this isn't new, it would seem that some of our employers are trying to evade or avoid these obligations in this regard. Section 189, the law on that, ladies and gentlemen, is nothing new. Everything has remained the same, but you will see that the theme in the case law is that many of our employers are trying to evade their obligations. The first case I'll be dealing with is Diverge versus Spanish Farm. This case reaffirmed that employers must follow the detailed consultation process under Section 189 before dismissals for operational requirements are valid. The court stressed that failure to give proper notice, to consult genuinely, or to disclose relevant information could render a retrenchment unfair. In this matter, the Labour Court once again reaffirmed key principles governing the fairness of dismissals for operational requirements and highlighted the consequences of failing to comply therewith. The brief facts in relation to this is Mr. Diverge was employed as a general manager of 2 hotels within the Vihan Group and was later promoted to group general manager when expansion was planned. 4 years later, the expansion plans were abandoned, and as a result, the company then decided to embark on a 189 process on the basis of financial reasons, and they believed that his position had become redundant. 189 notice referred to a proposed partnership as the reason for retrenchment, but he was later told that the true reasons were economic, including high overheads and the increase in our interest rates. Mr. Diverge challenged the inconsistency and proposed alternatives to dismissal, which included a redeployment. His suggestions were largely dismissed, and the consultation process was marred by massive hostility between the parties. He was offered an alternative role at approximately 65% less of the remuneration that he was earning. Reasonably, we would argue that he rejected that as an alternative, and as a result of his rejection, his employer then subsequently refused to pay him severance pay on the basis that it believed that he had unreasonably refused the alternative employment position. The court found that the dismissal was both procedurally and substantively unfair. Substantively, because the employer had failed to apply fair and objective selection criteria and unjustifiably rejected his bumping proposal as an alternative dismissal. Procedurally, the consultation process was not a genuine consensus-seeking process and was simply a tick box exercise. The court also held that the alternative role offered was unreasonable given the significant reduction in salary, and that Mr. Diverge's refusal was reasonable. He was therefore entitled to statutory severance pay. Of significance, ladies and gentlemen, this gentleman was only employed for 4 years. The court, however, was so aggrieved by how he had been treated by the employer that it awarded 8 months due to his length of service, the impact that it had on his future career prospects, because he had to take a massive knock in his new job in terms of salary, and as well as the unfair manner in which the process was conducted. The key takeaways for this, ladies and gentlemen, is that the rationale for retrenchment must be clearly and accurately stated in the 189. It doesn't help to just simply have generic terms in your 189 notice. Employers must apply fair and objective selection criteria, even where there's only one employee. Bumping should be properly considered where appropriate. Consultation must be genuine and meaningful, not a mere mechanical compliance exercise. An employee who reasonably refuses an unreasonable offer of alternative employment remains entitled to severance pay. The next case I'll deal with is NUMSA versus AMSA, the ArcelorMittal matter. I'm sure we are all aware this is the large-scale Section 189A process that had severely impacted Vereeniging and Newcastle. In this matter, NUMSA challenged the decision of AMSA to proceed with dismissals without reopening its consultation process. In January 25, AMSA had issued its notice proposing the wind down of its long business in both Newcastle and Vereeniging, which ultimately affected 2,200 employees. Consultations were facilitated by the CCMA and they were concluded in March 25. Shortly thereafter, however, AMSA then deferred the wind down and the retrenchment process for 6 months, following various discussions from the IDC as well as receiving TERS relief. In the months that followed, further developments occurred, including the prospect of an IDC acquisition, approval of a reduced electricity tariff, and operational efficiencies. Despite these changes, and despite the positive impact it had on the business, AMSA informed NUMSA in September 25 that the consultation process had merely been postponed and that dismissals would proceed. NUMSA, for obvious reasons, approached the Labour Court on an urgent basis in terms of 189A13, arguing that the changed circumstances were material and that employees had been denied a proper opportunity to consult on these developments. AMSA contended that the consultations had been properly concluded and that the underlying financial difficulties remained unchanged. In its conclusion, the court emphasized that Section 189 requires a meaningful joint consensus-seeking process, a theme, ladies and gentlemen, that we are all aware of, and that Section 189A13 empowers the court to ensure procedural fairness. It found that AMSA's circumstances had materially changed between March and September 2025, and that as a result of these changes, these developments had affected the timing, the scope, and the necessity of the retrenchments, and AMSA was therefore obliged to resume consultations before proceeding with its dismissals. This judgment confirms that where there is a substantial delay or material change in circumstances, an employer may not rely on earlier consultations. Retrenchment processes must reflect the employer's current operational reality, and consultation must be reinitiated where necessary to ensure procedural fairness. Then we have the infamous where the role has become redundant. In this matter, this is the De Veer versus Babcock Africa Services matter. A Michael De Veer had been employed within the Babcock Group for over 10 years. After the closure of its flying academy, he was transferred to the Babcock equipment in a newly created role as project manager. In July 2020, the company commenced a retrenchment process, citing the severe economic impact of COVID. De Veya's position was identified as potentially affected, and following full consultation meetings, was ultimately retrenched. He challenged his fairness, arguing that his role was not genuinely redundant, that the alternatives, including bumping, had not been properly considered, that the consultation process was predetermined, and that his severance and notice pay had been incorrectly calculated. The Labour Court, however, found that the retrenchment was indeed both substantively and procedurally fair. It accepted that the company had a genuine operational rationale due to the dramatic downturn in sales during the pandemic, and confirmed that fairness must be assessed based on the circumstances at the time of the decision. The court held that the redundancy does not require all associated work to disappear. It is sufficient if the specific role is rendered superfluous through restructuring. The court further found that there were no suitable alternative vacancies available, and that bumping was not automatic because Mr. De Veya didn't have the necessary skills for the role that he had proposed to be bumped to. The consultation process was held to be genuine, and the financial information provided was deemed to be sufficient. However, Mr. De Veya did succeed in part in terms of his referral, on the basis that the court held that the severance pay must be calculated on total remuneration and not basic salary alone. So our key takeaways from this matter is that employers may restructure and eliminate positions even where certain duties remain, provided the role itself has become superfluous. Consultation under 189 must be genuine and involve meaningful engagement, but does not require agreement or acceptance of employees' proposals. Employers must disclose sufficient information to enable meaningful consultation, but are not obliged to provide internal financial records if that it is not necessary or deemed appropriate for purposes of the consultation. Bumping is not an automatic entitlement. It applies only where the employee is suitably qualified and operationally able to resume the duties of the alternative role. Severance pay calculated on total cost and not be dealing with is the Fawu versus SA Breweries. This case concerned an urgent application, again brought by the union in terms of 189A13, focusing on procedural fairness in retrenchments. The applicant Fawu sought reinstatement of its members and disclosure of relevant information from SAB to enable meaningful consultation, and was ultimately successful in doing so. The facts were rather straightforward. SAB effectively had provided piecemeal information, refused to engage with the union properly, even during the facilitated processes, was deemed to be obstructed by the judge, and ultimately was then determined that the retrenchment was both unfair and procedurally unfair, given the fact that they had preempted certain redeployment roles. They hadn't meaningfully engaged in terms of the process, and ultimately had rendered the retrenchment process unfair. On that basis, the judge then ordered the matter to be reinstated, the retrenchment to be reinstated. The whole entire process had to start off all over again. And you will see in the judgment, ladies and gentlemen, that the judge had specifically ordered what was required by SAB in relation to the retrenchment process itself, which one would have assumed we all know as employers, but unfortunately that was the consequences that SAB had suffered as a result of its failure to meaningfully engage with FAWU and its members. So the overall trends, ladies and gentlemen, that we've picked up over 2025 is that our courts are demanding meaningful, not perfunctory consultation. Changing business conditions must feed into consultative processes. Positions versus tasks remain central, and early full disclosure is critical to fairness. What we also need to bear in mind is the legal reform in terms of the Code of Practice on Dismissal. As we know, this came into play in September 25, which seeks to align statutory guidance with established case law by reinforcing key principles governing retrenchments for operational requirements. Central to the code is the requirement that dismissal must be a measure of last resort, obliging employers to properly explore and document reasonable alternatives before proceeding. This, ladies and gentlemen, as we know, is nothing new. This goes back to the LAC judgments of Afrox, as well as the Oosthuizen versus Telkom judgments, which are late 90s cases. So this is nothing new to us. And the code also distinguishes between simple and complex retrenchments, recognizing that smaller employers may follow a more expedited process, while larger employers are required to engage, as we know, in a longer and more detailed consultation process. Importantly, however, it complements rather than replaces the thresholds that are set out in the LRA, affording courts flexibility in assessing fairness. In essence, while employers retain the right to retrench for genuine operational reasons, they must then demonstrate meaningful consideration of alternatives with the code aimed at promoting greater clarity and fairness in the process. And that is my section, Neil. Thanks very much.
Lovely, thanks, Eds. I got just one or two things that we can chat about. You mentioned the Labour Court and Labour Appeal Court stance on meaningful consultation and how important that is. That we shouldn't just be adopting a tick box exercise. And you're absolutely right. There's nothing new there really, and it's good that they've reaffirmed all of this. I just on the issue of redundancy, it's a difficult one because it's almost as though the decision has already been made. And now we're going through the motions a little bit. What do you feel about that on the consultancy issue?
Absolutely. I mean, let's be honest, by the time a company has decided to issue the 189 notice, the reality is that there probably inevitably will be job losses. But that being said, it doesn't mean that we can simply just participate in that process as employers, receive the information from employees and not deal with it meaningfully and not provide viable reasons as to why we are rejecting your proposals. Because ultimately you would have to demonstrate either at the CCMA or the Bargaining Council or in the Labour Court that you had considered the alternatives or the proposals that had been made by the employee. And if you don't have your paper trail in place in relation to that to justify why those alternatives or proposals were rejected, you may find yourself on the wrong end of the judgment.
Yeah, it's something else sometimes. You also mentioned the code of good practice. So the code of good practice now also deals with some good practice on retrenchments. Do you think, just looking at it, do you think that this code will make things easier for everyone to understand, or do you think it's going to make things more difficult when the Labour Court has to use it to assess the fairness of something?
I think it's a double-edged sword, Neil. The aim is obviously to try and make it simpler for employers. The guide is there, but ultimately the flexibility and the discretion sits with the court, as we know. So again, as I'd said earlier, you are going to have to be able to justify your processes. Even if you are a small-scale employer, there's obviously not the obligation as what you would have in terms of a large-scale employer, but you would still have to have the paper trail in place. You would still have to be able to justify why you did A, B, and C. So whilst it's simplified in terms of the code, that's not carte blanche for us now to simply say, well, we're a small environment, we're a small employer, we don't have the time to really focus on this. So here's a quick chat, Neil. Here's the 189. Let's have a chat for half an hour, and that's the end of your employment. That there's no suggestion that it can be that simple. And bearing in mind, we are dealing with people's livelihoods. So one has to respect the process and ultimately remember going forward that if I am challenged, how can I justify what I did? And that's the long and the short of it always in aspects of any procedural process that we follow as employers.
Yeah, I think what you said at the end there is very important, that we must be able to justify. And this idea or this case that you spoke about on ArcelorMittal, I think is a very useful reminder that you may start out facing a particular set of circumstances and you've plotted your 189 process based on that. But the longer that process takes, it gives an opportunity for things to develop, and you can't stay static. You've got to be flexible in that process.
Absolutely.
All right. Okay. Thanks very much, Eds. I think that was very, very useful.
Thank you, Neil.
All right. So up next is Merlisha Haripal. She's an executive in our team, and she's going to be chatting about the most interesting topic, I think. We've got all the collective bargaining stuff out the way, because that's normally the kind of boring stuff. Now we get into the sort of misconduct issues, which everyone wants to hear about. So if you want to take a bit longer on this one, that's also perfectly fine. I'm sure people are very interested in that one.
Okay, thank you, Neil. Good morning, everyone. Yes, I'm sure, as you can imagine, this topic touches on almost every aspect of employment law. So to look at the case law from the past year and what the courts have been telling employers was a task in itself. But I think I'm going to just touch on a few cases that I feel is important this morning. And if I had to summarize the theme in one sentence, I think it would be this: our courts are no longer tolerating lazy misconduct cases. So even though we have the Code of Good Practice, which my colleagues have spoken about earlier as well, on dismissal, and it is in place, and the overarching theme of the code is dialogue, fairness, and trying to make things a little bit informal when it comes to dealing with employees. Even with that, the courts are still looking at how the employer handles these investigations and these misconducts. And I think across the decisions that I'm going to talk about today, you'll see the same message, that there's a clear shift. Employers are expected to investigate properly when it comes to incidences of misconduct. They must draft their charges carefully. They must prove the misconduct convincingly at the hearings, and they must justify the sanction of dismissal with solid evidence. Now, this is not easy. You know, in the next few minutes, I'll take you through what I believe are a few of the key misconduct decisions from the past year and highlight the practical lessons that these cases give us for managing discipline in the workplace. So we'll be touching on things like dishonesty, drafting of charges, insolence, insubordination, sexual harassment, negligence, and even off-duty misconduct. So the first case that I'm going to touch on, and obviously because of time, I'm not going to go into the detail, but just the high-level decision that was taken and what actually happened in the case and the takeaway that we get from these cases. So I want to start with what is probably the most practically useful case for anyone that has to draft charges in 2026. So these are your employers, attorneys, human resource executives and officials. And this is our Marchi versus Shep case. Everybody was talking about it in January. The decision was delivered on the 19th of January this year. And it's probably the most important misconduct case for anyone who drafts charges. So in this case, a senior HR manager claimed that she was ill and she could not attend a company's awards event. But during that same time, she chaired a disciplinary hearing for another company and described herself as a director of that company. At the disciplinary hearing, she was charged with 3 misconduct charges, which was dishonesty and conflict of interest, among others. At the arbitration, she was acquitted of all the charges on the technical formulation of the 3 charges. The commissioner identified, however, that there was an unexpressed 4th allegation that emerged from the evidence, that she had abused the trust relationship by working for another entity during company time. The commissioner found that the real misconduct was this. She claimed to be ill and then performed paid work for a third party during company time. The dismissal was upheld. The labor court emphasized misconduct was part of the factual matrix of the dismissal, not a free-floating new charge. The labor appeal court confirmed this approach. The employee argued on appeal that the commissioner derived this unexpressed 4th allegation from the existing charges and evidence, and the labor appeal court disagreed. The court held that this was not a new charge. It was the true misconduct embedded in the evidence and narrative of the case. So what's the lesson here? Employers do not lose cases simply because the charge sheet is imperfect. The law doesn't require disciplinary charges to be drafted like criminal indictments. If the employee clearly understands the core misconduct and has the opportunity to defend it, the dismissal can still be fair. But, and this is important, this is not a license for sloppy drafting. The lesson is actually quite clear here. The narrative, the substance matters more than the label. So if the story in the charge sheet explains what the employer did, our courts will focus on substance over form. And the evidence must support the narrative. So I think that one is going to cause a lot of debate among lawyers, among HR people, but it is something that we have to take into consideration when drafting charges. It's important that the charges are properly framed. I don't think that it's a case of you can draft your charges in any fashion or any way that you like, as long as your evidence supports it. That's not what the judgment says. It just says that the charge sheet does not have to be perfect. And the narrative and the evidence must support what the employee understands the charges are and what the employer is saying the misconduct is. Okay, the next case that I'm going to be dealing with is the case of Lucchini South Africa versus CCMA and others. It's also a December 2025 case, and it's quite an interesting one because it deals on job hunting by employees. And I think it's a very important decision that may have surprised many employers. It dealt with a case where an employer tried to turn normal behavior into misconduct. So an employee was dismissed for taking preparatory steps to join a competitor during short time and retrenchment discussions. Now, this is not a restraint case, right? The labor court said no. The clauses prohibiting employees from taking preparatory steps, even to join competitors, was unenforceable. The employees have a constitutional right, in terms of Section 22 of the Constitution, to seek other employment, and that the court found that there was no conflict arising from them looking for work. Now, remember, this is not a restraint case. They're not joining a competitor. It's a misconduct case. They were charged for job hunting. The key takeaway here, and this is a big shift, is that job hunting is not misconduct. For many employers, I'm sure this feels counterintuitive, right? Because it's often, there's a strong emotional reaction when an employee starts looking for another job, and the employer finds out about it. But the court reminds us here that irritation at that is not misconduct. The employees are allowed to act in their own best interests. And the moment we start disciplining employees for normal career behavior, we move from discipline into retaliation. And the message from our court in this case is that the courts will not support that. So I just want to be clear. You can discipline employees for soliciting your clients, stealing or misappropriating confidential information or customer information, and working for a competitor during working hours or moonlighting. But this was not the case here, right? This was job hunting. So you cannot discipline someone for trying to improve their career prospects. And there's a warning to employers against trumped up charges motivated by irritation rather than misconduct. So I think that's a judgment that's probably going to irritate a lot of employers. But ultimately, I think it's right. You know, there is that protection in the Constitution that allows you to seek other employment. And an employer shouldn't be able to stop you or discipline you or limit your career prospects, you know, if you do that. I'm sure, Neil, I can see you
sorry, I know I'm interrupting you, but this case is wild. It's almost as though it's an unspoken restraint of trade that you're employed here and you will never leave. That's
yes, yeah.
No, unless exactly. We fire you.
And this is not a restraint matter. And you must remember in this matter also there were retrenchment and short-time discussions. So obviously that makes employees feel uncomfortable, you know, and uneasy, I think. And it's natural for them to then seek employment elsewhere. Perhaps this employee was not one of the affected employees, and that's why there was a level of irritation. But the message is still clear. Don't discipline someone or charge them trumped up charges for job hunting. So I thought that was quite an interesting development in our law over the last year. The next case is the Standard Bank of South Africa versus South African Society of Bank Officials and Others. It's a Labour Appeal Court decision. It came out at the beginning of last year, February last year, but it deals with a mistake or negligence versus gross negligence, which I think is something that comes up in employment and workplace, you know, in workplaces all the time. So I wanted to discuss it. So this case is actually critical for employers who label very expensive mistakes as gross negligence or gross misconduct. In this instance, a bank manager bypassed certain security protocols. They had authorized the lease agreement against bank policy and was dismissed for gross negligence. And the Labour Appeal Court here found that she was negligent, but that negligence was not gross. It did not reach the high threshold of gross negligence. For negligence to be gross, the court said that there must be a reckless disregard for consequences, not simply an error of judgment. And I think this is an important distinction. So essentially a bona fide mistake, even an expensive one, is not automatically gross negligence and therefore not automatically dismissible. And I think employers often assume that if a mistake has a costly consequence to the company, then it must be a gross misconduct. It must be gross negligence because it was an expensive mistake. But the court reminded us that the employee's intent, the context of the incident, and the previous conduct is actually the critical things that we need to look at. So from what I could see as a practical takeaway in this case is that if you want to prove as an employer gross negligence, you have to show more than just an error. You have to show recklessness, right? So in this case, the policy ambiguity played a big role, right? And so employers' policies must be clear. If you're going to, remember with misconduct, you have to show that there was a rule and the employee breached that rule. So the employee must understand the rule, that the rule must be clear in the workplace. And in this instance, there was policy ambiguity. So the case emphasized that the rules must be clear to employees. The employer in this case failed to prove the clear rule and failed to prove the foreseeability of harm. The misconduct must be corrected through training and coaching first. Remember, the key theme in our code of good practice is progressive discipline, right? Dismissal as a last resort, dialogue with the employees, investigations that are properly conducted. And in this case, then reinforces that principle that gross negligence requires foreseeability of harm plus a deviation from the reasonable standard. Right. In this instance, the Standard Bank appeal was dismissed and the employee was actually reinstated. So it can have far-reaching consequences. By the time it gets to reinstatement, your retrospective back pay is substantial. So as an employer, you should seek to get things right from the beginning. Then the next case that I want to deal with is Imatu on behalf of Saws versus City of Cape Town and others. And this judgment was delivered this year in January. And it dealt with off-duty misconduct, right? In this matter, there was a learner law enforcement officer who was caught driving under the influence of alcohol while off-duty in his own private vehicle. And he was arrested. The company then charged him for bringing the company into disrepute. It was actually the city of Cape Town. They charged him for bringing the city into disrepute and for the conduct. The arbitrator found that his dismissal was fair, but the labor court disagreed and ordered his reinstatement. Why? Because the employer failed to prove a nexus between the off-duty conduct and the employment relationship. And the court emphasized a critical principle. There's no automatic nexus between when you're off-duty and you misconduct yourself and the employment relationship. The court reaffirmed, I don't know if you remember the Hook test, there must be a clear, proven link between the misconduct and the employer's operational requirements or reputation. And in this instance, the city failed to prove that the off-duty conduct directly impacted the employer's ability to perform his work. In this case, the court found that the arbitrator misunderstood the nexus, considered irrelevant aggravating factors, failed to apply progressive discipline, and there was no actual evidence of reputational harm. Now, in this case, there's also other factors that come into play. The city had previously had a situation where a senior officer was arrested for driving under the influence. That person was also dismissed, but reinstated, and the city didn't appeal the reinstatement. They took him back into the employ. And in that instance, he resisted arrest. And so there was an inconsistency aspect between how they dealt with the senior officer and how they dealt with this particular employee. And the court found that that nexus between the misconduct and the employer's operational requirements or reputation is not automatic. Employers still have to prove reputational harm, impact on the employment relationship, or inconsistency in discipline that will not be, obviously that must be applied. There mustn't be a situation where you deal with one employee in a certain way and deal with another differently. So that was one of the reasons why the decision fell the way it did in this matter. And the city, like I said, previously reinstated a senior officer and didn't do it in this case. So the parity principle was also very decisive here. And the court criticized the arbitrator for speculation and assumption. They didn't prove that there was any reputational harm, but the arbitrator found that there was. There wasn't any evidence to support that. The practical takeaway here, I think, would be that reputation and position of trust is not enough without proof of a nexus. You must prove the nexus and you have to apply discipline consistently, which I think is right. The next case is CCI Call Centers Pty Limited versus PIN. It is an April 2025 decision and it deals with insolence and insubordination and trust. Now here, the Labour Appeal Court refined misconduct relating to insolence and insubordination. The case clarified the difference between insubordination and insolence and how trust ultimately affects the remedy. Here, the employee refused to perform payroll code duties. He insulted the CFO publicly, and he was found guilty of insubordination and insolence. But the arbitrator found that the dismissal was unfair and said that the dismissal was too harsh, but he didn't reinstate. He granted compensation. The labor court then ordered reinstatement. So why does this matter? Because when it was taken to the Labor Appeal Court emphasized serious misconduct does not automatically justify dismissal. You have to prove intolerability of continued employment. Now, this is in line with our code of good practice. This is a mistake as well that employers still make. Okay, you have to prove the misconduct. You must prove the rule. You must prove the breach. You must not forget the impact on the employment relationship. Trust breakdown is not automatic. It has to be supported by the evidence. Employers still make the mistake, and we see it all the time in practice, that if you make the allegation that the trust is broken down, that automatically entitles you to dismiss. It's not. Once the misconduct is proven, you still, as the employer, have to prove the breakdown of trust if you want to avoid reinstatement. And that's where I talk about the remedy that applies here. So context and workplace dynamics, power dynamics matter, right? Once the misconduct destroys the trust, reinstatement then would become unlikely. That's what would follow. But you have to show how the trust is broken. You must lead evidence on the breakdown of the trust. Even when the misconduct is serious, dismissal still requires proof that the employment relationship on an ongoing basis has become intolerable. Okay, then the last case that I'm going to be dealing with is the Pioneer Foods Groceries versus Commission of Conciliation, Mediation, Arbitration, and others, delivered very recently on the 10th of February. So it deals with remorse and sexual harassment and the sanction. So in this case, a supervisor hit a subordinate on her buttocks and denied wrongdoing. The commissioner then found the dismissal too harsh. The labor court disagreed and substituted the award with the finding that the dismissal was fair. And the reason the court held this is because they said a perpetrator of sexual harassment who sees no wrong in his conduct and refuses to accept responsibility places himself in a position where dismissal becomes the only suitable sanction. The court emphasized that a lack of remorse destroys the trust relationship, and long service then cannot save the employee. I think that's right. That the takeaway here is that the labor court's rebuke was clear. There's no such thing as an accidental physical harassment, right? Complex physical actions like grabbing someone, spinning them around cannot be dismissed as a spur of the moment instinct, right? So it's like your reflex versus what actually happened, the reality. Power dynamics matter a lot. Harassment by a supervisor toward a subordinate is a grave breach of trust. And employers should have a zero tolerance policy in that respect. And then the remorse factor, right? By denying the incident happened, the employee destroyed any chance of a rehabilitated working relationship. Without remorse, even in any misconduct cases, without remorse, dismissal is often the only appropriate sanction, right? And then also in this case, public accountability. Incidents that humiliate employees in front of their peers demand firm action to maintain a safe company culture. And I think this ruling reinforces that even if you have long service, you cannot shield an employee in a senior position from the consequences of this kind of serious misconduct. Employers have a duty to protect their staff, and the courts are obviously backing that up, that duty. All right, then in closing, if I had to leave you with, I think, a few key lessons from these cases, it would be, number one, substance beats form when it comes to charge sheets. Disciplinary charges do not need to be drafted like criminal indictments, but the employee must clearly understand the case that they are to meet and have a fair opportunity to answer it. Similarly, the employer must prove the charges against the employee or prove their narrative by way of evidence in a hearing. The second thing is not every mistake is gross negligence. You must prove recklessness. Third, job hunting is not misconduct. Fourth, Off-duty misconduct requires a clear and provable nexus to the workplace. Fifth, a pattern of failures can justify dismissal, especially for senior employees. And lastly, remorse and the breakdown of trust remain central in serious misconduct cases. So the employers must always prove the breakdown of trust. And I think what ties all of these cases together is a single message. Misconduct cases are no longer decided on instinct or sympathy or just because you make an allegation as an employer. They are being decided on the evidence. Evidence of the rule, evidence of the breach, evidence of a nexus, evidence of the breakdown of trust. So the employers who do the work will win their cases. The employers who take shortcuts may not. Right? The bar is raised. Even with the new code of good practice, misconduct dismissals must be, even though there's a informality aspect to the new code, in a way, it doesn't have to run like a trial. The message is still clear. The misconduct dismissals must be fair, evidence-based, proportionate, and employers who investigate properly and frame their charges correctly and carefully, and then present the evidence to support the misconduct, will be able to then justify the sanction convincingly. And it will be they will be well placed to then withstand any scrutiny in the CCMA, bargaining council, or in our courts. So I think that message is clear. Discipline smarter, not harder.
Yeah, I think it's a good point to end on. There's just one thing I want to chat to you about, and we workshopped this internally about 2 weeks ago. This judgment, the very first one that you spoke about on CHEP.
Yeah.
Now we know that the law and the LAC has told us in EOH many years ago that, and a bunch of other ones, Woolworths and other cases, that these are not criminal charges. We don't expect the precision of a legal draftsman when we draft disciplinary charges. I mean, the fact that we're still calling them charges is also a problematic issue, but
allegations of misconduct is probably
correct,
better.
or complaints or something. That's really what we should be talking about, because we don't have the criminal justice model anymore. But I mean, what the LAC has done here, and I remember we debated this internally in the team, that I think what the LAC has done here is very problematic, because they've taken EOH to another level. What they've said is that it doesn't even matter what your charges are. If you can kind of get an idea of what you're there for, then you must answer to that charge. And I think if you're an employee, that creates a bit of a difficulty for you. I mean, you imagine yourself being called to a disciplinary inquiry, and you're given 3 charges, as in CHEP. You're given 3 charges. So you prepare your defense to answer those 3 charges. And then it turns out at arbitration that actually there was a 4th charge and you should have figured it out.
And the arbitrator can figure it out. Yeah.
Yeah. I mean, to me, this doesn't sit well with me. I mean, the procedural fairness issues here, I think it's impossible. What you're requiring an employee to do is to guess what other possible alternative charge there may be that he has to answer. What do you think about that?
Look, I had a matter like this a few weeks ago. In fact, when the charges are not clearly framed, and then the evidence doesn't support the charges on top of that in the hearing, as the employer, even if the employee is guilty, you're going to have a problem. Because a person sitting as a chairperson, for example, or even an arbitrator looking at it objectively, is going to struggle to see what case the employee is to meet from if your charges are not framed properly. So while I accept the principle, and I understand the LAC's reasoning in saying the charges shouldn't be phrased like criminal indictments, I think there must be sufficient particularity in the charges to enable an employee to understand what case they are to meet. I don't think that and I think the evidence must then support that. If you have those 2 things happen in a misconduct hearing, then I think you'll be fine as the employer, and it wouldn't, you wouldn't have this thing of a CCMA commissioner trying to find a 4th charge from the evidence, which is what happened here. I think if you frame your charges with sufficient particularity, like there must be a date of when the incident occurred, what happened, what rule was broken, and what did the employee do, and what was the consequence. I think if your charges are simply phrased like that, and your evidence can support it, you'll be fine, and you wouldn't have this. So I do agree with the LAC in terms of It doesn't have to be drafted like a criminal indictment, but the evidence must then support the charges in the hearing or the narrative. So substance over form.
Yeah, I think that's right. I had other things I want to ask you, but there isn't time. I've got to let Mr. Wingfield get onto camera now as well. So thanks very much, Merlisha. I think that was great.
Thanks, Neil. Thanks, everybody.
All right, next up is Courtney Wingfield. He's a partner in our employment law team. Courtney, you're going to chat to us today about restraints, which you've been up to your elbows in the last 12 months.
Absolutely. Thanks, Neil, and thanks for the graveyard shift today. Thank you for that. I'm going to talk quickly about 4 cases. I'm not going to go through the facts in very much detail, but I just want to draw sort of the main points from these cases so we all have sort of a cheat sheet on what's happening in restraint law. The first one is a judgment from 2024 that kind of went unnoticed by, I think, a lot of people, even the people in the know of restraints. But it was Wacko Africa versus Ahmed. And essentially what happened is the employee left Wacko Africa and he went to a competitor. Obviously, there was no dispute of whether that was a competitor. So Wacko goes and they enforce the restraint for a year against Mr. Ahmed. Ironically, things starting off on the wrong foot for Wacko. The matter struck off the roll for lack of urgency in the Labour Court, but after the JP's intervention, it gets back onto the roll and eventually before Prinsloo. So the employee in this case, as many employees do when faced with the enforcement of a restraint, he made a with prejudice tender where he tendered essentially the entire restraint other than him not being employed by this competitor, the new employer. The new employer even agreed to be bound by these undertakings. But notwithstanding that, the employer persisted. Wacko Africa persisted with their application, saying, well, yes, we understand and thank you for the undertaking, but there's always the chance that the employee could unintentionally disclose the confidential information to the new employer, and the new employer would never know what is confidential information that is being disclosed by Mr. Ahmed. For example, in a meeting where he says, guys, I've got this great idea, etc., 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 and no one would really know whether that's confidential or not. So the court went through the usual sort of rigmarole of restraints. Is there a contract? Is there a restraint agreement? Yes. Was it breached? Yes, because he's employed by a competitor. And then the next one is there a protectable interest in the Basson versus Chilwan matrix there? And the court found yes. In essence, all that the law requires is that an employee, in theory, had access to information which he could, in theory, then disclose to someone. And then the second part of it was customer connections, and that the court found that he had built sufficient customer connections. The important part of this case, which is the reason I say it's really gone on under the radar, is some of us will know that in restraint agreements there's a clause saying the restraint agreement, should the restraint agreement become the subject of litigation, the restraint period, the 1 year period or 2 year or 3 year, will start running from the date that the litigation is finally concluded. And the court looked at that, and it looked at the purpose of restraint sort of protection, where you value on the one axis a timeline, and then on the other side is a dissipating value of the confidential information. So at the end of the restraint period, the 12 months, the parties have essentially agreed amongst themselves that we can't really keep you out of work. It sort of goes against your constitutional rights to be in work. And the court, thankfully, I think correctly found that you can't enforce a restraint from the date that litigation ends, say in 3 years' time in the constitutional court, because then you have 3 years plus the 1 year, which is against the whole purpose of what we're doing here. So the court found that the restraint would be enforced from the date of termination of employment. And really the value in this case was that the employer got a 6-month restraint against the employee, which would likely, could be dealt with through appeals. And they would get very little value out of the restraint. So that's number one. Number two is a case we were involved in, Future Packaging versus Pulte. The employee in this case worked at the company for 27 years. He was a shareholder and all of that, but the shares were sold, not really relevant. But what happened was, obviously, when he fell out with the management of the company, they charged him with a bunch of charges, emanating from the last 5 years. and the important bit here is that the employer in that case ran what Merlisha and Neil are talking about, these criminal trial disciplinary inquiries, which sort of engaged senior attorneys and even senior counsel and ran for about 6 months. Um, uh, and after which he was dismissed in May 2024. So essentially, Mr. Pulte owned the building from which a competitor operated. They sent in the employer, sent in the ex-employer, sent in a investigator wearing a wire. He had a whole conversation with Mr. Pulte about what do you know about boxing and etc. etc. And obviously, Mr. Pulte was caught hook, line, and sinker there. And obviously that was Annexure A to the founding affidavit, the transcript of that conversation. But anyway, the employer went to court and tried to enforce the restraint which he had for 3 years. And the court relied on two LAC decisions, recent decision of 2024, that a restraint for more than 2 years without any real proper justification is unreasonable these days. And then the court took into account the important bit of this case is that Pulte was essentially placed on the sidelines. He was out of the business. He was on suspension since December 2023 for the 6 months for the period of the disciplinary inquiry. And the court in those circumstances said the restraint period will start running not from the date of dismissal, but from the date of suspension, the date on which Pulte had no access to anything anymore. And the court then essentially just made you sort of cut it in the middle and said, well, we'll enforce it for 2 years, not 3, from the date of suspension. And essentially the employer in that case got, I think, 3 or 4 months value out of the restraint. The last sort of restraint case I want to talk about is famous, I suppose, now. People are sort of getting on the bandwagon of back sports, but in this case, everyone I think should know that there was an employee who was dismissed from his old employer. He then started very aggressively competing with his ex-employer. And the ex-employer brought a restraint of trade agreement for a period of, and the period was 12 months. There's obviously a whole sideshow of he was threatening the old employer's managers and all of that. And you can sort of read between the lines of the judgments there, where it got quite violent. And we actually spoke to the attorney around this case, and he said it was sort of a full data breach attack on the IT systems of the ex-employer. But that's how nasty these things can get. So the Labour Court bizarrely found that because the employee had been dismissed, and his dismissal wasn't challenged in any sense, but just on the basis that he had been dismissed, the restraint of trade agreement couldn't be enforced at all, and sort of sent shocks through the restraint community. The LAC, thankfully, corrected this error quite shortly afterwards, but in reality, the company only really got 3 months of the restraint protection maximum out of that. The next one is a judgment. It's not really restraint aligned, but it's close by. It's G4S Deposita versus Harumsa. It's a judgment from November, but it was just released last Friday. In essence, the employee Harumsa, she worked for G4S. She was the head of risk, and essentially they have a Google Business Drive with all the company's confidential information on the drive. So she resigned on the 4th of August, but on the 2nd of August being so the 4th of August is the Monday, the 2nd of August being the Saturday, she goes into the office with 2 people, and she essentially removes all of her physical belongings from the office files and things like that. On Sunday, she spends the day at home downloading essentially all of the confidential information of G4S. And just to give you perspective, she normally downloaded on a monthly basis 100 documents, and on this day she downloaded 1,083 documents. So then she was playing some sort of subterfuge here. She goes on the Monday and she says, no, I really wanted I'm resigning, but I really want the sales director role, which the company went back to think about, and then they offered it to her, ironically. And then she declined it and said, no, I'm going to Fidelity. So then what the employer did in this case, there was no restraint agreement, and that's why I say that restraint agreements are important, but the employer was required to embark on an Anton Pillar style application, where if anyone knows an Anton Pillar, it's essentially you go in the cover of night and you arrive unannounced at the subject's house, sort of FBI style with the blue jackets with the yellow writing, and you sort of just rifle through everything that they've got. They're required to stand back, and you sort of confiscate everything that they've got, so that you can prepare for your case later. And she was caught red-handed. She was caught with, basically everything under the sun, the memos, the everything. And those who've had cases on, run Anton Pillar applications will know that essentially once you find out that they've got everything, the world is yours, and the employee sort of acts as you wish, or the ex-employee. So the employee's only defense to this whole thing after the part B of the application, the interdict application was brought, was no, she only took the information so that she could do a proper handover on the Monday. And obviously that was just ridiculous. So the court in that case obviously granted a sort of interdict to prevent her from using confidential information going forward, and then costs on the highest scale. So those are my cases, Neil. No hard questions, please.
Thank you. I'm hosting, so you have to answer them. Let's just chat about back sports. You and I did an article last year in the Business Day where we spoke about the practical realities of back sports. There you had a situation where the employer had a restraint, it was valid, it was enforceable. They discover a breach, they go to the labor court. The labor court scores an own goal. And back sports is left with very little remedy. Yes, they correct it at the labor appeal court stage, but then they're left with 3 months of their restraint. Before that, the employee's been running riot, doing whatever he feels like doing, essentially. This may be counterintuitive for lawyers to suggest that we shouldn't litigate, but what is the solution here? I mean, employers all have confidential information. They have trade secrets. They have proprietary information that they want to protect. Are restraints on their own enough here?
No, I mean, I think the short answer is no. You see, the point is whether you enforce the restraint or don't enforce the restraint, you get an order enforcing the restraint, or you get an employee saying, no, I will be bound by it, or they give undertakings. There's in no world can you ever ensure that the information is secure. It's impossible. The thing, you have to start with sort of internal regulation, and you have to say, these are our systems. Only X amount of people, these guys who are required to access the information, have access to the information. And should something, say, be downloaded from a drive, for example, then you must that must raise alarm bells with IT, or something put on a flash stick, or all of these other things. But in reality, there's no way to, as a matter of certainty, protect confidential information. I mean, restraints help, but it also could be a situation where you get the restraint, the court grants in the employer's favor, and then the employer still discloses the information. So,
and what about it? And we spoke about it in the article. What about it? Utilizing alternative methods. So, I mean, it's all good and well to have a restraint, and we're not suggesting that employers shouldn't. I think we must make the point clearly that restraints are still valid and very useful deterrents, and they should be put in place. But I think it's part of a much larger puzzle, isn't it? I mean, you've mentioned internal controls. Are there other things that we could look at?
Yeah, I mean, the first thing is obviously getting employees to stay with you. I mean, in the situation of, say, G4S, the employee was obviously unhappy and she wanted to go, and I don't think anything G4S could have done would have allowed her to stay. But I mean, there's also other methods to deal with this, like retention payments, long-term incentive schemes, all these other things. So there's various methods that people should use. I mean, restraints have value. Otherwise, you're in a situation as they were in G4S. You've got to go and Anton Pillar. You've got to go and do all this other stuff. And if you don't even Anton Pillar, you're going to have to bring a unlawful competition claim. And those, as you know, Neil, I mean, those are incredibly difficult to succeed with. So restraints are very valuable, but I think the value that they have practically, and what the law says, sort of creating a sterile environment that those two don't exist in parallel anymore.
I think we got to get a little bit creative, and I know we've workshopped this in-house as well about perhaps introducing longer garden leave provisions in conjunction with the restraint, tying sign-on bonuses or short-term incentive payments, or even long-term ones. Long-terms, by their very nature, try to retain employees in employment. But if you were to make bonuses subject to a restraint or a repayment regime, I think that may also assist. Yeah.
Absolutely. If I can just also make the point, I don't think our judges are intentionally trying to destroy this area of the law, as many sort of pure contractual lawyers may seem to think, and sort of outdated. I think those notions are based on outdated thinking. I think realistically, we must remember that restraints are not just contract law. It's employment law, it's constitutional law, and all these other factors come in. So it's very easy to say, oh well, you must be bound by the contract that you signed. But in reality, you have a job, you have a family to take care of, and all of that. But that's kind of swept to the side. I think the judgments that we see, I mean, at least back sports certainly, and even maybe Wacko Africa to a lesser degree, they're just symptoms of a bigger problem that I think that the law as it currently is no longer sort of taking into account the proper interests. And you can see it from some of the judgments of the Labour Court that judges are getting creative to find ways out where they get a sense I don't want to enforce this thing, so let me find a way out of this thing. And I think that the simple solution is rather amend the law rather than have judges do fancy footwork.
Yeah. All right, good. Thanks, Courtney. That was very, very useful and interesting. I think we've got about 4 minutes left. If you have questions, please put them in the Q&A because we're happy to take them now. Perhaps the panelists can just turn their cameras back on, and then we can work through these questions. The first one here is from Anonymous. It says, as an employer, I've always wondered what happens if genuinely no alternatives exist. How then can the employer prove that consultation was authentic and not foregone? I think that's for you, Hedda.
Yeah, so by the time the employer issues the 189, the hope or the requirement is that employer obviously looks to see if it has any alternatives. So the majority of the 189 notices that you will receive or that we see is it'll say, look, we've tried to consider whether there are alternatives. We've exhausted the internal process. We are unable to identify any alternatives. Be that as it may, you are now invited, employee, to submit any proposals or alternatives that you have, which, as I'd said earlier, we have to, as employers, properly consider and be able to justify why you are rejecting those proposals. So it doesn't mean that if you haven't got an alternative or haven't considered an alternative or are unable to identify an alternative, that it's a foregone conclusion in terms of the process. The whole idea is to then meaningfully engage with the employees for purposes of determining whether or not they may have a viable option that could then determine or avert their retrenchment.
Yeah, I think that's right. That's that redundancy issue we spoke about, that even though it may seem obvious, we've still got to look for an alternative there. Yeah.
There may be something that the employee comes up with that the employer hasn't properly considered.
Perfect. Thanks, Ed. Darren has a question here. I think this is for you, Nikki. In light of Section 197 and the recent case law developments in the latter part of 2025, are we seeing a jurisprudential shift in how the courts are approaching second-generation outsourcing, particularly in relation to service providers and contractors?
Thanks for that question. Well, in considering the two judgments that I spoke about earlier today, I don't believe that we've seen a jurisprudential shift in respect of those two. If anything, it's an application of well-established principles set out in the Tsasima judgment of the Constitutional Court. I think it will be quite interesting to see how the King Coetzer judgment in the Constitutional Court differs from Tsasima. I think ultimately the case law tells us that we have to analyze and identify the nature of the business before and after the alleged transfer to determine whether the business has been transferred as a going concern. And that's a well-established principle that dates back many years. So I personally don't think that there's been a shift in our jurisprudence, but we'll obviously see how the latest judgment develops on this issue.
Yeah, I think this notion of generational transfers is also not something that's really relevant. I remember it was a big thing with SAA, but Really, I think what our law says is that regardless of the generation, we've got to scrutinize the transaction, most likely.
Yeah, correct.
Okay. Thanks, Nikki. And then Darren has one last question for us. Courtney, this is for you. In terms of the restraint of trade provision, is paying an employee a restraint of trade allowance monthly? Is this a higher enforceable element versus the traditional restraint of trade provisions?
Yeah, absolutely. I mean, obviously, our law says that you're not obliged to pay someone for their restraint if you know, at least concerning the enforceability question. But I think it certainly helps a lot. I mean, you say to an employee, you know, and this is one of the big things I think that our law should change is, I mean, say for instance, in Chile, you have a requirement, you have a constitutional right to employment, and you have to pay. And you know, I think it would be very difficult for an employee to say, listen, I am being paid. Say essentially, I've been paid either ahead of time or I've been paid during the restraint period, and that is, you know, the enforcement of the restraint is still unfair. I don't really think you can get far with that, and it also serves as a sort of internal measure to protect against the enforcing of overly long restraints. I mean, if you say you must pay the employee for the period of the restraint, say after or during employment. Do you think an employer is ever going to say, yes, I want a 5-year restraint when there's no real reason for it? An employer is going to look at it and say, you know, I can justify paying 6. It's going to pinch my pocket, but I think I need it because of the confidential information. So I think it's a big point, largely unexplored in South African law.
I think it's interesting though, because it's almost as though it would soften the blow of a restraint, but really whether a restraint is enforceable or not, it's got very little to do with whether you pay. It's got to do with whether an employer has a protectable interest, no?
Yeah, I suppose if you get to the point of protectable interest and you say, yes, there is a protectable interest, I think weighing the sort of prejudice between the parties. I mean, you know, the whole pacta sunt servanda versus right to work. And I mean, to a lesser degree, the right to fair labor practices, which hasn't also been explored properly. But yeah, absolutely.
Yeah, very good. All right. I see we've had 2 more questions. This one is a very long one. So we'll do one more. Bianca, we'll do yours. My query is regarding retrenchment. During the consultation process, preference rehire for future positions was agreed upon. However, this was not included in the signed retrenchment agreement. Is the employer bound by what was agreed in consultation? Hedda?
Generally, or always in terms of the 1893, if you're looking at the Labour Relations Act, it also deals with the re-employment aspect. So it is a point that you have to consult on and agree on ultimately. So whether or not it's actually in the agreement, Neil, I don't know if you agree with me, but I would say that it's a statutory obligation that has to form part of the consultation process. And if there is a possibility of re-employment, it doesn't necessarily, obviously, given the word re-employment, I don't need to be placed in the same position I held prior to my retrenchment, but I should be afforded the opportunity of a preferential treatment if I am qualified for that position, and I can then take up that role within a certain period of time that I then am considered for that position. So I would say yes, it should form part. And if it doesn't form part of the agreement, or the LRA specifically says that you need to deal with that.
Yeah, I suppose it's one of those things that's fact specific. It would depend how the agreement was concluded, what was discussed, because we know about interpretations, what information was available to the parties these days. And Ndumeni has changed all of that. Thanks, Hedda. So thank you very much to all of our panelists. We've come to the end. Unfortunately, we couldn't answer all of the questions. If you do have them, you have our contact details. Please send them through to the persons who spoke. I'm sure they'll be more than happy to assist you. Once again, the recording is available online. It'll be up on our YouTube channel probably within an hour after the end of this webinar. So thanks very much for joining us, and we'll see you next time.